Jefferson County Court of Law Number 2 is in session. The court is in session with jail review docket on today's date of June 2024. I have before me two cases. They are cause numbers 23 CCCR 1968 and cause number cause number M3341. Let me strike that. Cause number M334214. Both cases are Charles of Texas versus Chelsea Nicole Sams. Ms. Sams, is that your full name?
Yes, sir.
Ms. Sams, would you please raise your right hand? Ms. Sams, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Sams, you may put your hand down. How are you doing, Ms. Sams?
I'll be doing great later.
Okay, you can understand that. Now, Ms. Sams, you are represented in your case by Attorney Katz. Attorney Katz, how are you doing?
I'm doing good. Thank you.
And Mr. Katz, do you waive a record in Ms. Sam's case?
I do.
And state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking me. Ms. Sams, I have before me a document that is titled Motion to Revoke Probation. This motion to revoke probation was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Chelsea Nicole Sams, was tried on November 6th of 2023 for the offense of theft. You was found guilty and your punishment was assessed at 180 days confinement in Jefferson County Jail and a fine of $1,102. That sounds like a fine.
I think, Judge, that included restitution.
Let me see. Let me see. Judge. Okay. Sentence. Yeah, the fine was $500. State, you have like to make a trial amendment to this motion to revoke?
Yes, Your Honor, I'm looking at it right now. It looks like the fine was $500.
Right.
Excuse me, and the remainder was restitution.
Yeah, but the motion say,
I'm I don't see that restitution listed on the actual original plea of punishment.
right.
This is
23 CCCR 1968. This. Amend the MTRP.
And you're writing, Your Honor?
Yes,
Yes, no objection.
if he doesn't have any objections. Just scratch. Yeah. Like the same thing as on both of them.
On both of them.
Yeah, I guess you're gonna have to put,
I don't see the restitution. listed.
no. You're gonna have to make this for your first amended motion. You know, just Put your initials on it, dated. Okay, now, Mr. Katz, you have any objections to state's first amended motion?
No objection, Your Honor.
Okay, no objections. Now, Ms. Sams, I have before me state first amended motion to revoke probation. And it states that on or about November 6th of 2023, that you was tried for the offense of theft. Court found that you were guilty. Punishment was assessed at fine of $500. Confinement in the Jefferson County Jail for a period of 180 days. Your probation was 18 months. During this 18-month probationary period, are you editing this document? It says that it's locked. That's 1968. It says that I tried to get into this document. It says that it says it's not currently locked by another user for editing.
I'll send it to you. I am on it. Well, let me say that is sent to you.
Could you hit unlock? I don't have an unlock on my side. Let me, yeah, I can't get into.
No, I'm not on.
Now, Ms. Sam, in this motion to revoke your probation, there are 3 allegations. State, are you abandoning allegation number 2?
Yes, Your Honor.
No objection, Your Honor.
Okay. State is abandoning allegation number 2. Ms. Sams, therefore, they will be proceeding on allegation 1 and 3. Allegation number 3 alleges that you, Chelsea Nicole Sam, failed to report to Jefferson County Probation Office as ordered by the court month of March 27, 2024 and February 20th, 2024 as directed in violation of your probation, of your condition 4 of your probation order. Is that true or not true?
True.
Allegation number 3 alleges that you, Chelsea Nicole Sam, failed to attend and complete treatment recommendations for inpatient treatment from your substance abuse evaluation. Is that true or not true?
True.
Ms. Sam, are you pleading true to allegations 1 and 3 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Right.
Okay. Ms. Sam, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. You recognize this document?
Yes, sir, I do.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked MTRP, which means motion to revoke probation, true to allegations 1 and 3. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification, defendant's right of appeal, you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Now, Ms. Sam, before you signed and initialed this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Sam, are you a citizen of the United States?
Yes, sir. I
State
am.
offer states law.
Any objections?
No objection, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. Ms. Katz, you're advising counsel. Ms. Sam, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Sams, your attorney, Mr. Katz has advised and counseled you. Are you satisfied with his representation?
Yes, very much.
Has he provided full, effective, and competent legal representation?
Yes, sir, yes.
Ms. Sams, I will accept your plea of true to allegations 1 and 3. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of true, the state's offering 14 days in the Jefferson County Jail with credit for 14 days to tax and retire court costs, and this is to run concurrent with clause M33214.
Okay. Ms. Sam, the state is offering that you serve 14 days in the Jefferson County Jail. However, you're not required to serve any more time in the Jefferson County Jail on this case because you've already served 14 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Sam, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Very much, yes, sir.
And do you accept the state's offer?
Yes, sir, I do.
Okay, Ms. Sam, I'll follow the plea bargain agreement that you have entered into with the state. Now, this case will also run concurrent with cause number M334214. Mr. Katz.
Yes, sir.
Changed it.
Yes, sir.
Do you have the other entity, Judge? And I'll correct that real quick as well.
Okay. Ms. Sams, I have before me in cause number cause number M334214, a document that is titled First Amended Motion to Revoke Probation. Mr. Cass, do you have any objection to the state filing its first amended motion today?
No objection, Your Honor.
Okay, no objection. All right. Now, Ms. Sam, in the state's first amended motion to revoke your probation, it alleges that you, Chelsea Nicole Sam, on November 6th of 2023, in County Court at Law number 2, that you were found guilty for the offense of theft. Punishment was assessed at 180 days confinement in the Jefferson County Jail and a fine of $500. The confinement was probated for a period of 18 months. In this motion, there are 3 allegations. State, are you abandoning allegation number 2?
Yes, Your Honor.
No objection.
No objections? State is abandoning allegation number 2, and that simply means that they will only be proceeding on allegations 1 and 3. Allegation number 1 alleges that you, Chelsea Nicole Sam, failed to report to the Jefferson County Probation Office as ordered by the court for the months of March 27, 2024 and February 2024 as directed in violation of condition 4 of your probation order. Is that true or not true?
True.
Allegation number 3, the defendant Chelsea Nicole Sam failed to attend and complete treatment recommendation for inpatient treatment from her substance abuse evaluation. Is that true or not true?
Yeah.
Ms. Sam, are you pleading true to allegations 1 and 3 freely and voluntarily?
Yes, I am.
And are you pleading true because it is true or because they are true?
That is correct.
Ms. Sam, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir, I do.
On page 2 of the same document, there's a set of initials. On the line next to the box says checked MTRP, which means motion to revoke probation, true to allegations 1 and 3. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
That is true.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
I do.
And is this your signature on the line that's titled defendant? At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
I do.
State, I have before me State's Exhibit number 1. State, would you like to offer State's 1?
Yes, Your Honor.
No objection, Your Honor.
No objection. State's Exhibit number 1 will be admitted. And Ms. Sam, just for the record, prior to signing and initiating these documents, you went over the documents. Your attorney went over the documents with you.
Yes, sir.
Everything in these documents true and correct to the best of your knowledge.
Yes, sir.
Okay. And Mr. Katz, you've advised and counsel Ms. Sam. Is there any evidence that she's currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Sam, your attorney, Ms. Katz, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Ms. Sam, I will accept your plea of true to allegations 1 and 3. I will find that you are mentally incompetent to stand trial. I also find that your plea and waivers were freely and voluntarily given. I also find that there is sufficient evidence to revoke your probation. Probation is hereby revoked. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what's the agreement?
In exchange for defendant's plea of true, the state's offering 20 days in the Jefferson County Jail with credit for 20 days into tax and retired court costs. This is also to run concurrent with the companion case 23CC-CR1968.
Okay, Ms. Sam, state is offering that you serve 20 days in Jefferson County Jail. However, you would not be required to serve any more time in Jefferson County Jail because you've already served 20 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. This case will run concurrent with your companion case, cause number 23 CCCR 1968. Ms. Sams, do you understand the state's offer?
Yes, I do.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Now, Ms. Sam, if you do not have anything else holding you in jail, you will be getting out of jail today.
Okay.
Okay, now, Ms. Sam, you're gonna stand next to the bailiff in front of our court coordinator, follow his directions. Once you finish following his directions, you can follow him and you have a blessed day. And Mr. Katz, you're free to go and you have a blessed day.
Thank you, Your Honor. I appreciate you.
Okay.
You can have a seat. I have-
Oh, she's not ready yet?
Hey.
Grab some Germex real quick.
That's it. The Jefferson County Court of Law number 2 is back in session. Court is in session in cause number 23 CCCR 0290. Case of the style of state of Texas versus Tiffany Ashley Zamora. Ms. Zamora, is that your full name? Ms. Zamora, would you please raise your right hand? Ms. Zamora, did you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Zamora, you may put your hand down. How are you doing, Ms. Zamora? You okay? That's good. Ms. Zamora, you're representing your case by your attorney, Tom Burbank. Attorney Burbank, how are you doing?
Doing fine, Judge.
Mr. Burbank, do you waive a record in Ms. Zamora's case?
We do.
Ms. Zamora, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Tiffany Ashley Zamora, on or about February 6th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense.
Criminal trespass of a habitation, Judge.
Yeah, I was looking for the habitation in here. Okay, yeah. You was charged with criminal trespass of a habitation. Do you understand what you've been charged with? Yeah, of a habitation, somebody's house. Okay, now to this charge, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges. Okay. Ms. Zamora, I also have before me a document that is titled, hold on a minute. It's titled Misdemeanor Plea Admonishments. This document was filed by the Jefferson County District Attorney's Office. In this document, Ms. Zamora, it also is labeled as State's Exhibit Number 1. Do you recognize this document? Speak up.
Yes, sir.
Okay. On page 2 of the same document, there are two sets of initials. One set of initials is your initials of your attorney, and the next set of initials, TZ. Your initials, did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document, it's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case, and you have the right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Is this, you recognize this document? And is this your signature on the line that's titled Defendant? Ms. Zamora, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Zamora, are you a citizen of the United States?
State offer states one.
Any objections?
No objection, States.
No objection. State's Exhibit Number 1 will be admitted. Mr. Burbank, you've advised and counseled Ms. Zamora. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Zamora, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Zamora, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of no contest, the state's offering 13 days, time served, and 2 tax and entire court costs.
Ms. Zamora, the state is offering that you serve 13 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 13 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Zamora, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Ms. Zamora, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Zamora, if you do not have anything else holding you in jail, you should be getting out of jail today. Okay. Ms. Zamora, would you please stand in front of our court coordinator, follow the directions of the bailiff? Once you finish following his directions, you can follow the bailiff and you have a blessed day. And Mr. Burbank, you're free to go and you have a blessed day.
That was a good one.
Same to you.
See you later. Linda?
Jefferson County Court at law number 2 is back in session. The court is in session and calls number 23 CCCR 1880. Case is style of State of Texas versus Jamard K. Anderson. Mr. Anderson, is that your full name?
Yes, sir.
Mr. Anderson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Anderson, you may put your hand down. How are you doing, Mr. Anderson?
Good.
That's good. Now, Mr. Anderson, you representing your case by your attorney, Attorney Marva Provo. Ms. Provo, how are you doing?
I'm doing fine.
Ms. Provo, do you waive a record in Mr. Anderson's case? And the state is representing this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
I'm doing well, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Anderson, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Jamar K. Anderson, on or about March 17th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A, less than or equal to 2 ounces. Mr. Anderson, do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead guilty? Not guilty, no contest. Plead guilty. Now you're pleading guilty freely and voluntarily. It's a Class B. And are you pleading guilty because you are guilty? Okay. Mr. Anderson, I have before me a document that is titled Misdemeanor Plea Admonishments, also labeled State's Exhibit Number 1. Do you recognize this document? Okay, now, Mr. Anderson, this is a Class B misdemeanor. The range of punishment is minimum 0 days to maximum 180 days confinement in the Jefferson County Jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand the range of punishment for this Class B misdemeanor?
Yes, sir.
All right. On page 2 of this same document, there are a set of initials on the line next to the box that says check guilty. Did you place your initials JA on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Anderson, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Anderson, are you a citizen of the United States?
Yes, sir.
Stay up for state 1.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you've advised and counseled Mr. Anderson. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Anderson, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation? Mr. Anderson, I will accept your plea of guilty. I will find that you're free, that you're mentally competent to stand trial, and that your waivers are freely and voluntarily given, and that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement in this case?
For defendant's plea of guilty, state is offered 9 days time served, court calls Saxon retired.
State is offering Mr. Anderson that you serve 9 days in Jefferson County Jail. However, you will not be required to serve any time in Jefferson County, any more time in Jefferson County Jail on this case, because you've already served 9 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. Mr. Anderson, do you understand the state's offer?
Yes, sir.
Do you think the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Anderson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Anderson, if there is not anything else holding you in jail, you should be getting out of jail today. Mr. Anderson, you can stand in front of our court coordinator stand next to the bailiff, follow the directions of the bailiff. Once you finish following the bailiff directions, you'll be free to follow the bailiff and you have a blessed day. Please stand over there. All right. Victor Jackson.
Judge, can you send,
Which one?
Chelsea Sam, let's send them both back to you. instead of
Oh.
writing them over.
Guilty's name ready for.
No.
Yeah, she played.
Thank you.
And let's see here. And yeah, Zamora played too. And so we have Zamora and Sam. Victor Jackson.
No, all the rest.
Let's see. 92 minus 69. Miss. That's four cases, huh?
Yes, five.
He has five total cases, 3 dismissed, 2 plea, Your Honor.
$60. 9269. 52. Okay.
Okay.
Counts, it was like a rush. I had to go to surgery, but it was right here. I had to leave. I was in jail for, I think, for a trespass, and I had to leave and go to the hospital. And they had to do it. They had to spit it. They had to cut it right there.
Okay. Now, Mr. Okay, the court is in session in 5 cases, cause numbers 24 CCCR 0992, cause number 24 CCCR 1369, cause number 24 CCCR 1452, cause number 24 CCCR 1491, and cause number 24 CCCR 1501. All 5 cases are styled the state of Texas versus Victor D. Jackson. Mr. Jackson, is that your full name?
Yes, sir.
Mr. Jackson, would you please raise your right hand? Mr. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Jackson, you may put your hand down. How are you doing, Mr. Jackson?
Pretty good.
That's good. Now, Mr. Jackson, you're representing your cases by your attorney, Attorney Mulva Provo. Attorney Provo, do you waive a record in Mr. Jackson's cases? Mr. Jackson, I have before me in cause number 24 CCCR 1491, a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Victor D. Jackson, on or about May 1st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, a burglary of a vehicle. Mr. Jackson, do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Yeah, it's a Class A. Thanks. Okay, now, Mr. Jackson, I have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to boxes check no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's 2 boxes checked.
Yes,
The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Will you understand that statement?
Yes.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Jackson, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney wanted?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Jackson, are you a citizen of the United States?
Yes, sir.
Still for stage 1.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you advised in counsel. Mr. Jackson, is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Jackson, your attorney, Ms. Provo has advised in counselship. Are you satisfied with her representation?
Very.
Has she provided fully effective and competent legal representation?
Yes, sir.
I'm gonna need his affidavit read. Mr. Jackson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defendant's plea of no contest, the state is offered 30 days jail with credit for 14 days on this case. This is to run concurrent with 24 CCCR 1501. And for this offer, the state is dismissing the cases 0992, 1369, and 1452.
What's the court cost in this case?
Which one is that?
This is 1491.
277.
Do we have his
He doesn't have one in there.
do we have one in
But
any?
neither one of them.
I'm just trying to figure if his last one, yeah. Yeah, I need one. Mr. Jackson,
Yes, sir.
the state is offering that you serve 30 days in the Jefferson County Jail. You'll be given credit for the 14 days that you've already served. The court cost in this case is $277. Will you be able to pay the $277 court cost?
No, sir.
Okay. Ms. Provo, could you hand that document to Mr. Jackson? And Mr. Jackson, could you take some time to just have a seat, take some time to fill that I'm gonna need, Jefferson County Law number 2 is back in session. Court is in session in clause number 24 CCCR 1491. And before we went into recess, Mr. Jackson, the court stated that the state was offering a confinement of 30 days in Jefferson County Jail, but you get credit for 14 days. The court asked you if you could pay the court cost, which is $277. You stated that you could not pay it. The court has before it an affidavit of indigence. Do you recognize this document? And is this a document that you just filled out?
Yes, sir.
Now, is everything in this document true and correct? Okay, Mr. Jackson, the court is going to find that you're indigent. Based on the finding of indigency, the court costs in this case will be waived. That means you won't have to pay it. Okay? Now, Mr. Jackson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Jackson, this case will run concurrent with cause number 24 CCCR 1501. The state will be dismissing cause numbers 24 CCCR 0992, cause number 24 CCCR 1369, and cause number 24 CCCR 1452. And Mr. Jackson, you understand the state's offer?
Yes, sir.
Think the state's offer is fair and just?
Yes.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Jackson, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Jackson, we will proceed or move on to your next case. Your next case is cause number 24 CCCR 1501. And in this case, Mr. Jackson, I have before me a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. This information, in this case, alleges that you, Victor D. Jackson, on or about April 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Jackson, do you understand what you've been charged with in this case?
Yes, sir.
And to this charge, Mr. Jackson, how do you plead?
No contest.
No contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Jackson, I have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled State's Exhibit Number 1. You recognize this document? On page 2 of the same document, there's a set of initials VJ on the line that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Jackson, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over in these documents?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? State, I have before me State's Exhibit Number 1. State, would you like to offer State's 1?
Yes, Your Honor.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you've advised and counsel, Mr. Jackson. In this case, are you satisfied with his, well, is there any evidence that he's currently mentally incompetent to stand trial?
No.
And Mr. Jackson, your attorney, Mr. Provo, has advised and counseled you in this case.
Yes,
Are
sir.
you satisfied with her representation?
Ma'am.
Has she provided fully effective and competent legal representation?
Yes, sir.
Mr. Jackson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence. If I find you guilty beyond a reasonable doubt. What is this court process in this case?
277.
And state, do we have a plea bargaining agreement?
We do, Your Honor.
And what is that agreement?
For defendant's plea of no contest, the state is offered 30 days jail with credit for 22 days in this case. This case will run concurrent with the previous case, and the state has agreed in exchange for this plea to dismiss the 3 cases discussed earlier.
Mr. Jackson, the state is offering that you serve 30 days in Jefferson County Jail, you'll be given credit for the 22 days that you've already served. The court cost in this case of $277 will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure because the court has found that you are indigent in this case as well. This case will run concurrent with cause number 24 CCCR 1491. The state will be dismissing cause numbers 24 CCCR 0992, 24 CCCR 1369, and 24 CCCR 1452. Mr. Jackson, do you understand the state's offers?
Yes, sir.
Do you think that the state's offer, this case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Jackson, I'll follow plea bargaining agreement that you have entered into with the state. Mr. Jackson, you're gonna stand, you're gonna have to have us, no, you're gonna, cause we waiving a court cost.
Yes, because I have to put something on there. But Judge, you, do his dismissals by the time.
Yeah, I will. Okay,
I should be done.
okay, Mr. Jackson, just have a seat. Where you want to sit?
Oh.
Okay, just have a seat in that first chair, and then you'll wait for your name to be called. By the wall. Lester Lewis is gonna be next. Jefferson County Court at law number 2 is back in session. Court is in session with 3 cases. They are cause numbers 24 CCCR 1012. Cause number 24 CCCR 1013. And cause number 24 CCCR 1025. All 3 cases are styled the state of Texas versus Lester J. Lewis. Mr. Lewis, is that your full name?
Yes, sir.
Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis?
I'm doing okay.
That's good. Now, Mr. Lewis, you're represented in your cases by your attorney, Attorney Marvel Provo. Attorney Provo, do you waive a record in Mr. Lewis's cases?
Yes, we do.
Mr. Lewis, in cause number 24 CCCR 1012, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Lewis, it alleges that you, Lester J. Lewis, owner about March 18 of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal mischief. Mr. Lewis, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Lewis, how did you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Lewis, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled Trial Court Certification of Defendant's Right of Appeals. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement?
sir.
The second box that checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document before me that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes,
Mr. Lewis, before you signed and initialed these documents, did your attorney go over these documents with you?
sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Lewis, are you a citizen of the United States?
Yes, sir.
Stay up for stage one.
Any objections? No objections. States Exhibit number 1 will be admitted. Ms. Provo, you've advised and counseled Mr. Lewis. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Lewis, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Lewis, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defense plea of guilty, the state has offered 60 days jail with credit for 11 days. This offers to run concurrent with all 3 of his cases here today.
Okay, with the next 2 cases.
Yes, Your Honor.
What is the court cost?
277.
Do we have an affidavit on here? Mr. Lewis, the state is offering that you serve 60 days in the Jefferson County Jail. You will be given credit for the 11 days that you've already served. The court cost in this case is $277. Will you be able to pay the $277 court cost? Okay. I need this affidavit. Wait, we have an affidavit that we're going to print off and we'll give it to you for you to review. Okay. Oh, okay. Mr. Lewis, I have before me a document that is titled Affidavit of Indigence. Mr. Lewis, I'm gonna hand this document to your attorney and she will hand this document to you for you to review. Mr. Lewis, do you recognize that document that your attorney is handing you? On page 2, there's a signature above the line on the top left that says defendant's signature. I think you signed below the line. You see at the top left-hand side, where it says defendant's signature, he signed below the line. Is that your signature?
Yes, sir.
Okay, now, Mr. Lewis, is everything on that document still true and correct today? Okay, Mr. Lewis, the court is gonna find that you're indigent. Based on the finding of indigency, the court cost in this case will be waived. That means you will not be required to pay. Because pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court is finding you indigent. So the court costs in this case will be waived. All right, now, Mr. Lewis, do you understand? And well, Mr. Lewis, this case will also run concurrent with cause numbers 24 CCCR 1013, cause number 24 CCCR 1025. Mr. Lewis, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Lewis, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Lewis, I'll move to your next case. Your next case is cause number 24 CCCR 1013, case of style of state of Texas versus Lester J. Lewis. Mr. Lewis, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Lewis, it alleges that you, Lester J. Lewis, on or about March 18th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal mischief. Mr. Lewis, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Lewis, how did you plead guilty? Not guilty, no contest.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes,
Mr. Lewis, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are a set of initials on the line next to the box that check guilty. Did you place your initials on this document?
Yes, sir.
On the next document that's titled, on the same document, but the next page, do you recognize this signature above the line that's titled defendant? Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement?
sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And I also have before me a document that is titled Discovery Certification. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Lewis, before you signed and initialed these documents, did your attorney go over these documents with you? And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Lewis, I will accept your plea of guilty. State,
Stay up,
Black office states 1.
Yes, Your Honor.
Okay.
No objection, state's exhibit number 1 will be admitted. And Mr. Lewis, your attorney, Ms. Provo has advised and counseled you. Are you satisfied with the representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes.
Okay, and Ms. Provo, you have advised and counseled Mr. Lewis, is there any evidence that he's currently mentally incompetent to stand trial? Okay. Mr. Lewis, I will accept your plea of guilty. I will find that you're mentally incompetent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For plea of guilty, the state has offered 60 days jail with credit for 11 days. This is run concurrent with his other two cases.
Okay, Mr. Lewis, the state is offering that you serve 60 days in jail. You'll be given credit for the 11 days that you've already served. The court costs in this case, $277 will be waived pursuant to Article 42.15 because the court has previously found that you are indigent. And based on that finding of indigency, the court costs in this case will be waived. This case will run concurrent with cause numbers 24 CCCR 1012, cause number 24 CCCR 1025. Mr. Lewis, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Lewis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Lewis, we're going to move on to your next case. The next case that I have, Mr. Lewis, is cause number 24 CCCR 1025. And in this case, Mr. Lewis, I have before me information that was filed by the Jefferson County District Attorney's Office. And in this information, Mr. Lewis, it alleges that you, Lester J. Lewis, on or about March 14th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of violation of protective order. Mr. Lewis, do you understand what you've been charged with? And to this charge, Mr. Lewis, how do you plead guilty, not guilty, or no contest? And are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
All right. Now, Mr. Lewis, I have before me on my tablet, a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on the line next to the box that said guilty. You place your initials on this document.
Yes, sir.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification, defendant's right of appeal. You recognize this document.
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Mr. Lewis, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that she went over?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
Yes, sir.
State, I have before me states 1, state like offer states 1.
Yes, Your Honor.
No, yeah.
No objection, states exhibit number 1 will be admitted. Mr. Provo, you advising counsel, Mr. Lewis, is there any evidence that he is currently mentally incompetent to stand trial? And Mr. Lewis, your attorney, Ms. Provo is advising counsel you. Are you satisfied with her representation?
Yes, sir.
That she provided full, effective, and competent legal representation? Mr. Lewis, I will accept your plea of guilty. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
For pleading guilty, the state has offered 60 days in jail with credit for 11 days. This is running concurrent with the previous two cases.
Okay, now, Mr. Lewis, the state is offering that you serve 60 days in Jefferson County Jail. You'll be given credit for the 11 days that you've already served. the court costs in this case will be waived because the court has previously found that you're indigent, and pursuant to Article 42.15, the court costs in this case will be waived. This case will run concurrent with your companion cases, cause numbers 24 CCCR 1012 and cause number 24 CCCR 1013. Mr. Lewis, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Lewis, I'll follow people are in agreement that you have entered into with the state. Mr. Lewis, just have a seat in that first chair and wait for the court coordinator to call your name. And this will conclude your case. And once you finish at the window, you can follow the bailiff, and you have a blessed day. Melton, huh? Melton Richard or Richard? Oh, hold on, before you do that, I need to get him back up here. I need to read that to him. Yeah, I need to read him while he's waiting. I can read him the written, yes, admonition. Now, Mr. Lewis, you have before you a document that is titled Model Written Admonition on the Ineligibility to Possess a Firearm or Ammunition. So in accordance with Texas Administrative Code Section 176.1, the court hereby admonishes you or warns you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion of burning substance or any device relatively convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapon made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful Carrying Weapons. Penal Code Section 46.04, Unlawful Possession of Firearm. Penal Code Section 25.07, Violation of certain court orders or conditions of bond in a family violence, child abuse, neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Lewis, this written admonition that was given to you is for your records. You can keep that document and just please have a seat at the first chair on the wall. Next case is Melton Richard or Melton Richard.
So are we. And there's a cafe in the courthouse basement.
I'm gonna say which states.
Oh.
Take it off and put it back on.
I threw up the $625 money right there.
I don't know.
Threw it up, because I wasn't asking for money.
We would have to
And I
add.
needed it, so I threw it up.
And
I didn't even like it.
we start.
So I got to call, I was checking. I know what day I made it on. Around 10, 20
Select another thing.
in the morning. And you know, I got to look into the
I have that.
I made it on that day.
And in terms of section 106.8,
And I can bring my.
order of the code of ordinances should go here.
That's all I can need. Then I get.
What are-
It's not record as much I do my check. But I think that if they can identify, they should, send the numbers to, HJ Canton. Give me the, I get my, 620.
Okay, Jefferson County Court Law number 2 is back in session. Court is in session, calls numbers 24 CCCR 1364, calls number 24 CCCR 1395, and calls number 24 CCCR 1403. All three cases will style the state of Texas versus Melton Richard or Melton Richard?
Melton Richard.
Richard, okay. Mr. Richard, would you please raise your right hand? Mr. Richard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Richard, you may put your hand down. How are you doing, Mr. Richard? That's good, Mr. Richard. I have before me in cause number 24 CCR 1364, a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. This information that was filed by the Jefferson County District Attorney's Office alleges that you, Melton Richard, on or about May 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Richard, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Richard, how do you plead? Guilty, not guilty, no contest?
I get it.
Guilty? Now you're pleading guilty?
Trying to.
Okay, now, Mr. Richard, are you pleading guilty freely and voluntarily?
Yes, sir, because I returned all the evidence.
Okay, now, Mr. Richard,
They never retrieved all the evidence.
okay, I understand. Now, Mr. Richard, And you're pleading guilty because you are guilty. Is that correct?
Yes.
Okay, now, Mr. Richard, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of the Defendant's Right of Appeal, you recognize this document?
Yes.
And on the next document that's titled Trial Court Certification of the Defendant's Right of Appeal, you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. First box says check states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
Second box says check states that you are waiving your right to an appeal, which means you're giving up the right to an appeal. You understand that statement?
Yes.
I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Richard, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that she went on?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Richard, are you a citizen of the United States?
Yes, sir.
Stay up for states 1.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you've advised and counseled Mr. Richard. Is there any evidence that he is currently mentally incompetent to stand trial? And Mr. Richard, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Richard, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
Yes.
And what is the agreement?
The agreement I'm sorry, Your Honor, is this the trespassing case or the theft case?
This is the trespass.
Okay, thank you. The offer on this case is 19 days time served. It's to run concurrent with the theft case, 24 CCCR 1395, and the state will be dismissing 24 CCCR 1403, as well as refusing the received trespassing case M24 1785.
Okay. What's the cause number that you state is refusing?
It's M-24-1785.
And that's the DA's number, right?
That's right, Your Honor.
Okay. Okay, Mr. Richard, the state is offering that you serve 19 days in the Jefferson County Jail. You'll be given credit for 19 days. That simply means you would not be required to serve any more time in jail on this case because you've already served 19 days in jail. Therefore, you'll be given credit for time served. The court costs in this case will be taxed and retired. That means that you will not have to pay the court costs because the time that you spent in jail has already paid it off. This case will run concurrent with cause number 24 CCCR 1395. The state will be dismissing cause number 24 CCCR 1403, and the state will refuse DA number M-24-1785. Mr. Richard, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Richard, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Richard, we'll move on to your next case. And your next case, Mr. Richard, is cause number 24 CCCR 1395.
Pardon.
And in this case, Mr. Richard, I have before me an information that was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Melton Richard, on or about May 15th of 2024, while you were in Jefferson County, Texas. Hold on, let me back up. Oh, hold on a minute. Yeah, I clicked on the wrong one.
I know, sorry.
Hold on a minute. Yeah, it alleges that you, Melton Richard, on or about April 29th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Richard, you understand what you've been charged with?
Yes, ma'am.
And
Yes,
to,
ma'am.
and to this charge, Mr. Richard, how do you plead? Guilty, not guilty, or no contest?
Yes, ma'am.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, now, Mr. Richard, I also have before me a document that is titled Misdemeanor Plea Admonishments. It's also labeled as State's Exhibit 1. You recognize this document? On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document? And on the next page, there's a signature above the line that's titled Defendant. Is this your signature?
Yeah.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes.
Is this your signature? I mean, not, excuse me. There are two boxes
Yes, sir.
checked at the top of this document.
Yes, sir.
The first box that's checked states that this is a plea bargain case. You have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal. You understand that statement? I also have before me a document that is titled Discovery Certification. Recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Richard, before you sign and initial these documents, did your attorney go over these documents with you? And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? State I have it.
States one.
Any objections? No objections. States Exhibit number 1 will be admitted. Ms. Provo, you advise and counsel Mr. Richard in this case. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Ms. Provo, you are waiving a record in his cases, that's correct?
Yes, ma'am.
And Mr. Richard, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Richard, I'll find that, I'll accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And we'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement in
We
this
do,
case?
Your Honor.
What is the agreement?
For defense plea, the state is offered 23 days time served. This will run concurrent with the previous case, court cost tax retired, state's dismissing case 1403 and refusing M-24-1785.
And this case is running concurrent with cause number 24 CCCR 1364.
Yes, Your Honor.
Okay. Okay, now, Mr. Richard, state is offering that you serve 23 days in Jefferson County Jail. You'll be given credit for 23 days that you've already served. Therefore, you'll be given credit for the time that you've already served. he would not have to serve any more time in jail in this case. The court costs in this case will be taxed and retired. That simply means that the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. This case will run concurrent with cause number 24 CCCR 1364. The state will be dismissing cause number 24 CCCR 1403. And the state will refuse to accept DA number M-24-175. Mr. Richard, do you understand the state's offer?
Yes, yes, sir.
Do you think that the state's offer is fair and just?
Yes, ma'am. I mean, yes, sir, I'm sorry.
And do you accept the state's offer?
Yes, sir.
Okay, now, Mr. Richard, you're gonna stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following his directions, you'll be free to go, and you have a blessed day.
Thank you, yes, sir.
Tommy Williams, thank you.
All right.
Starting back in about an hour.
Actually, it's supposed to be here at 1.
Oh.
Right.
Uh-oh.
Yeah. Let's see. You're welcome. Tommy Williams is next. Oh, okay, Tommy Williams.
About. Yeah, that's yeah.
Jefferson County Court at number 2 is back in session. The court is in session in cause number 24 CCCR 1428. The case is style of state of Texas versus Tommy Hunter Williams III. Mr. Williams, is that your full name?
Yes, sir.
Mr. Williams, would you please raise your right hand? Okay, Mr. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Williams, you may put your hand down. How are you doing, Mr. Williams?
I'm blessed.
That's good. You can't beat that. You can't be better than being blessed. Now, Mr. Williams, you are represented in your case by your attorney, Attorney Marvin Provo. Attorney Provo, do you waive a record in Mr. Williams' case?
We do.
And Mr. Williams, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Tommy Hunter Williams III, on or about May 2nd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Williams, do you understand what you have been charged with?
Yes, sir.
And to discharge, Mr. Williams, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Williams, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on the line next to a box that's checked, no contingent, which means no contest.
Yes, sir.
Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line
Yes,
that's
sir.
titled Defendant?
Yes, sir.
At the top of this document, there are two boxes
Yes,
checked.
sir.
The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification on paper. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Williams, before you signed and initialed these documents, did your attorney, Ms. Provo, go over these documents with you?
Yes, sir.
And did you read and understand everything that Ms. Provo went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Williams, are you a citizen of the United States?
Yes, sir.
State off this one.
Any objections? No objections. State's exhibit number 1 will be admitted. Ms. Provo, you have advised and counseled Mr. Williams. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Williams, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation in the affidavit?
Yes, sir.
Okay. Mr. Williams, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given to state. Do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
In exchange for defendant's plea of no contest, the state's offering 30 days in the Jefferson County Jail with credit for 13 plus court costs. In addition, for this plea, the state will also refuse clause M24-1925.
Okay. What is that cause number again?
It's listed as M-24-1925.
Oh, a minute. Okay, now, Mr. Williams, the state is offering that you serve 30 days in Jefferson County Jail. You will be given credit for the 13 days that you have already served. Do we know his court cost is 277?
277.
The court cost in this case is $277. Will you be able to pay the $277 court cost?
No, sir.
Okay, just hold on a minute. I need to get a copy of your affidavit of indigence that I will hand to your attorney and she will hand it to you for you to review.
Oh, Mr. Holmes, can I ask you a question?
Well, you need to talk to your attorney first. She's your counsel. Okay, because anything that you say can and will be used against you in a court of law. All right. So if you want to say anything, you can tell your attorney, she can advise you whether or not you should make a statement on that.
Okay, I'll speak to you then.
Yeah, y'all can go over there.
My voice is-
Yeah. You know what you
Like that
mean?
this evening.
Could be allergies. Yeah, that tropical storm.
Yeah, we got the outskirts of it. It wasn't too bad, Brian.
Yeah, it was windy though.
It was bad. Oh, my.
Okay, Mr. Williams, I have before me a document, I'm gonna hand it to this attorney. A document that is titled Affidavit of Indigence. Do you recognize that document? document that they did that at the jail. On page 2, there's a signature above the line that is titled Defendant's Signature. Should be top left. Is that your signature?
Yes, sir.
Now, is everything on that document still true and correct today?
Yes, sir.
Everything, okay. Now, Mr. Williams, the court is going to find that you're indigent. What that means is you will not be required to pay the court costs of $277, and that's pursuant to Article 42.15 of the Texas Code of Criminal Procedure, because the court has found that you're indigent and you're unable to pay it because of your status of being indigent. Now, Mr. Williams, the state will be refusing to accept the DA cause number or the DA case number M-24-1925. Okay, so there was a case that they had another case, but they're not gonna accept it. They're gonna refuse it. Now, Mr. Williams, do you understand the state's offer? You have to speak up.
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Williams, I'll follow the people are in agreement that you have entered into with the state. Mr. Williams, just have a seat in that first chair by the wall. And then when the court coordinator is ready for you, you're gonna come up to a window, you're gonna follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can follow the bailiff, and you have a blessed day. And this will conclude the calling of the court's jail review docket on today's date of June 20, 2024, in County Court at Law number 2. The court will be in recess. We're supposed to have our jury coming back at 1 o'clock. So the court will be in recess until 1 o'clock. Yes, you may be excused, Ms. Provo.
Judge,
I'll see some footage, Judge.
that,
Bill, if you could get the jury, just call them by individual names, have them come in. You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23 CCCR 2380. Case is styled State of Texas versus Broderick Dwayne Mathis. Let the record reflect that Mr. Mathis is present in court with his attorney Lindsey Scott. Let the record reflect that the state is present with Assistant Criminal District Attorney Haley Simmons and Attorney Andrew Hubel. Ms. Simmons, is the state ready?
State's ready, Your Honor.
And Ms. Scott, is the defense ready?
Defense is ready, all right.
Okay, you may be seated. Let the record also reflect that the jury is now present and seated in the courtroom. Ms. Scott, if you're, you can call your next witness.
Your Honor, defense calls Kirk Thomas.
Kirk Thomas, what, is he outside?
Yes, sir.
Yes. Mr. Thomas, would you please come forward? Mr. Thomas, would you please raise your right hand? Mr. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Yes, sir. Mr. Thomas, you may put your hand down. Mr. Thomas, you can have a seat on the witness stand. Mr. Scott, you may proceed.
Thank you, Your Honor. Mr. Thomas, would you say your full name?
Kirk,
Where do you live?
9240 West Road.
Are you part of the Dornballs family in Nederland?
Yes,
And do you have ownership in some of the Dornballs company?
yes,
Do you and your family own a bunch of property there where you live in Port Arthur?
yes.
And about how many acres is that property?
95,
And how long has that property been in your family?
19, 20.
And do you own and operate some businesses out there on the property?
Yes, sir.
And what businesses are those?
The cattle company, mostly agricultural, and the trucking company that I own personally. Some oil and gas activities, and then business with pipeline.
Okay, do you run a business called KT Trucking and Cattle?
Yes, I did.
And that's a trucking company as well as it deals in cattle.
Yes,
What type of use is the property zone for out there?
heavy industrial.
And do you have a shop or a place where you run those businesses on property?
Yes,
Well, what do you have out there?
a big warehouse shop that we work on the trucks and some hay barns. Big parking areas, lay down yards.
And then where do you actually live? I mean,
In the back of one of the big shops.
Okay, so it's not like a separate house or anything, but you do stay out there.
Yes,
And is this also the location where you run the land farm operations?
correct.
Is your property a residential, commercial, or industrial establishment?
It's all heavy industry,
And you also have your residence there, correct?
correct,
And run your commercial businesses there, correct?
correct.
Okay, so let's talk about the land farming. Explain to the jury what that means, what that is.
Land farming is, I guess, a byproduct of an ancient drill. It's a horizontal drill, in the construction aspect of laying pipe, could be municipal pipe, could be water pipe, could be oil and gas pipe. As the pipe goes in, the dirt and mud has to be removed from the ground in order for the pipe to fit. So drill mud is the hole that the pipe makes as it goes in.
And does the drilling mud have to be moved out of the site?
Absolutely,
And so then it's gotta be disposed of somewhere.
correct.
Okay, and, do places like on your property where the land farming occurs, where you can dispose of that drilling mud require a permit?
Yes.
And is that from the railroad commission? That's who regulates that?
Yes,
So anytime you've had drilling mud disposed of on your property, you've had a permit from the railroad commission to do that?
that's correct.
Because not just anybody could go dump that mud on the property?
No.
Okay. And so do you have, well, tell me how it works. Do you make agreements with the pipeline company? They contact you and say, can we come bring our mud there?
When the pipeline, sometimes it's the operator, which would be Exxon Enterprise. Sometimes it's a contractor that the producer hires, usually one of the two.
And who hires the trucks? Do you go out and find the trucks that are coming? Does the company, or do you even know what trucks are bringing the mud? Or you've just made an agreement with the contractor or a pipeline company that yes, you can come bring your mud here?
Yes, I'm gonna have a contractor, a mutual agreement with either the operator or the contractor, and my part's pretty much done.
So you don't find the trucks?
No.
Do you even know what trucks they're using or that are coming or what company it is? Is that information that you have in advance?
Sometimes I know the company, but I have no clue about the trucks.
And on this date, that this ticket was written to Mr. Mathis on March 30th, 2023, were y'all in the middle of a job?
Yes,
And mud was being delivered, drilling mud was being delivered to your property.
that's correct.
And to your knowledge, was Mr. Mathis working for Bryant Oil Field Services at that time?
I believe he was.
Was he going to be coming down Sassine Avenue to enter your property?
Yes,
Okay, now the Sassine Avenue about your property.
Yes.
And it dead ends right into your land, correct?
it does.
You have a gate there that the trucks can go through and all of that.
That's correct.
Are these trucks, like Mr. Mathis was driving that day, hauling the drilling mud, engaged in the steady hauling of material?
Yes,
Are they carrying unusually large or heavy loads?
yes, Bill.
And this is where you maintain all your operating facilities for KT Trucking and the cattle company and the land farming operations, correct?
That is correct.
Do you also keep your own trucks for KT Trucking on the property out there?
Yes, I do.
And the cattle trailers and all of that?
Correct.
As well as other heavy equipment, machinery, whatever you need to operate those businesses?
That's correct.
Do the jobs that involve your trucks, the KT Trucking trucks, do they originate on your property?
Correct.
That's where all the trucks and the cattle trailers and trucks leave from.
Right.
And the jobs involving the hauling of the drilling mud, do they terminate on your property?
Yes,
And that's where the unloading happens.
that is correct.
Do you also have pipelines on your property?
Multiple,
Like about how many would you say?
20.
And do the pipeline companies also come on and off the property to maintain the pipelines?
Yes, they do.
Do they also use Sassine Avenue?
Yep.
Are there a limited number of locations to this, in this area to dispose of drilling mud?
Yes, there is
Why is that?
a lot of wetland issues.
Do you know of a bunch of other people that do this type of thing that you do out there?
I know a few.
Like, would you say like a couple?
Maybe two.
There's not a lot of other locations, that these trucks could go to.
No.
I'm gonna hand you what's been marked as defense exhibit 3 through 17. You'll just look through the photos. Are all of these photos that you took,
Yes,
are they photos of your property?
yes, they are.
Well, defense exhibit 3 and 4, those are Google Map photos, correct?
That's correct.
And are those Google Map photos that you yourself pulled of your property?
Yes, and those are not my property. 3 is not.
Oh, well, okay, I'm sorry. 3 and 4 are those Google Map photos of Sassine Avenue
Yes,
leading into your property. And then defense exhibits 5 through 17, no, 18, are those photos you yourself took on your property of your property?
yes, they are.
Do they fairly and accurately depict what's shown in the photos?
Yes.
And have they been altered in any manner?
No, ma'am.
Your Honor, I'd like to offer an evidence, defense exhibits 3 through 18, for the tender on to the state.
Okay, no objection, defense exhibits 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 are admitted.
Okay, I'm looking at defense exhibit 3. Is that a Google Maps photo of Sassine Avenue?
Yes, it is.
And does it show leading into a kind of big gate that goes onto your property?
That's correct.
And is that also what defense exhibit 4 is a photo of? A Google Maps photo of Sassine?
That's correct.
Is there another entrance to your property?
Yes, it is.
Where's the other entrance?
Off of Westport Off the Road.
And does that entrance go over the LMBA canal?
Yes, it does.
And what does the LMBA stand for?
Lower Natchez Valley River Authority.
Did you have to make an agreement with the LMBA to have that entrance?
Yes, I did.
Is that agreement for private use?
Yes.
Have they ever been willing to give you an agreement to use that entrance for public or commercial use?
No, ma'am.
And in fact, have they asked you not to use that entrance for commercial vehicles?
That is correct.
And why is that?
It's a private agreement. Number one, the agreement states as such, and the water, they're concerned about the water, and the water's municipal water for 2 or 3 cities. They just don't, they don't want any accidents or take all precautions they can.
It's basically for other drinking water, correct?
That's correct.
And they don't want you to accidentally dump drilling mud into it, correct?
Correct.
And so did they allow you to build a small bridge at that entrance?
Yes, they did.
And do you feel that that small bridge is even safe for commercial vehicles if they would allow you to?
Not over time. No.
Does it also go over some pipelines?
So,
And does it also go over the Union Pacific Railroad? Have you attempted to have commercial vehicles enter that way, that entrance?
yes, I have,
And has that been problematic?
yes.
Why?
I recall two incidents. One, just getting into the railroad track is the first obstacle. The turn's pretty bad. We rolled I think it was a bottle truck or 18-wheeler. I say we, the driver, missed the turn and rolled it over, blocking the railroad, the driveway, and Westport off the road for an extended period of time. And the second instance was actually one of my trucks trying to get out, and the ground clearance of some of the trucks bottoms out on the railroad tracks and off the trailer, which also blocked the railroad, the driveway, and wasn't off the road for an extended period of time.
Is it steep there coming up over the railroad tracks at that entrance?
Yes, that's the problem.
I'll show you what's been. Just to make sure. Okay, Judge, the first set of exhibits were, 3 through 17. I'm now showing him, I don't know if I said 17 or 18. I'm now showing him, it was 17. Defense exhibit 18. Is that also a photo that you took?
Yes.
And does that show the low ground clearance, not far from that entrance at your home?
That's correct.
Does it fairly accurately depict what's in the picture?
That is correct.
Over into evidence, defense exhibit 18.
So you guys no objections, Your Honor?
Okay, no objections, states exhibit eight, I mean, defense exhibit 18 is admitted.
Okay, is this just, has TxDOT also acknowledged that there's low ground clearance there coming up the railroad track?
That is correct.
Is that just a sign put up by TxDOT showing that?
Yes, ma'am, Texas or county, or could be both.
Okay. But regardless of the issues you've had, has the LMBA, specifically told you, that they let you have that access there, so you had a way into and from your house, but it is definitely not for commercial vehicle use?
That is correct.
And that's, just a private entrance, correct?
That's what the agreement states. Yes.
Is Southern Avenue the only viable entrance into your property for commercial vehicles?
Yes, it is.
And so Southern Avenue comes out on Highway 365, correct?
Yes, ma'am.
You said your property was zoned for heavy industrial use. Are you able to use your property for any heavy industrial uses if you can't get a commercial vehicle on or off the property?
Absolutely not.
In those approved land uses for heavy industrial use, does that include the storage and parking of commercial vehicles?
Yes, it does.
When the trucks, hauling drilling mud enter via Southine, are they entering at the closest street to your location that they can safely enter into your property?
That is correct.
Are they driving no farther than they have to get to their destination and then turning around and going no farther than they need to leave?
That is correct.
They basically come directly in, unload, turn around and go directly home, right?
That's right.
How long have you worked in the oil and gas industry?
Since I was very young.
And has your family's, Dornball's company worked in the oil and gas industry for many years?
Yes.
In your personal experience, working with the pipeline companies, working in this field of oil and gas, based on everything you know about all of that, do you think that the hauling of drilling mud is routine in the state of Texas?
Yes, ma'am.
Routinely done? Do you think it's routine in our area in Southeast Texas?
Absolutely.
And would you say that these trucks are operating in routine commerce when they're bringing in this drilling mud?
Yes, they are.
Are you familiar with Port Arthur City Ordinance 10641?
No, there's two ordinances. Explain that or read it to me.
I'm gonna show you what's been marked as defense exhibit 1 and 2. 1 is 106-8. Two is 106-41. If you look at Defense Exhibit 2 at 106-41 and go to section B and go down to number 13,
Yes, ma'am.
have you seen or known or heard about this ordinance before?
Yes, I have.
Okay, based on what you know about that particular ordinance, do you believe you need a permit to use Southie Avenue for commercial vehicles?
No, ma'am, I do not.
And is that just based on the sort of exception provided in 106-41B13?
And yes, ma'am, it's based on that and probably some other things too. Yes, ma'am.
When it says the public works is authorized with the police department in conjunction with the chief of police to designate the routes along the streets of the city, which must be followed by commercial vehicles engaged in the steady hauling of material of any kind, or which are carrying unusually long or heavy loads. And these trucks hauling the drilling mud are pretty big, right?
Correct.
I mean, how heavy are these trucks approximately?
Max weight is 80,000.
Okay, and it goes on to say that no such vehicles shall be prohibited from using any street for the purpose of going directly to or from any residential, commercial, or industrial establishment abutting on such street for purposes of routine commerce, provided that they enter such street at the closest intersection to their destination and proceed no farther than the next intersection in order to return to their point of entry. Based on that, do you believe that the commercial vehicles hauling drilling mud to your place can come without a permit?
Yes, I do.
Before you were familiar with this ordinance, did you attempt to get a permit?
Yes, I did.
And were you able to?
Very temporarily. Yes,
I mean, at one time you had a permit, correct?
yes,
Did you post a bond for the road?
yes, I did.
How much was the bond? How much was the bond?
150,000.
Did they ask you for a bunch of information about the trucks and all that kind of stuff?
Yes, ma'am, I did.
Did you have all of that information?
No, ma'am, I gave everything.
Even since March 30th of 2023, when this ticket was written, have you gone back again and attempted to obtain a permit from the city to use that thing for these commercial vehicles?
Yes, I have.
Have you been able to get one?
No,
Have you found that process to be long and difficult?
yes,
Once you've submitted the application and provided the information that you could, would they take a long time to get back to you?
we still don't have it, yes.
And that is also something that has to go in front of the Port Arthur City Council, right?
I believe so.
Which adds additional time usually, right?
That's correct.
And explain to the jury how these jobs work. I mean, do you have that kind of time?
Not on normal jobs. I guess you can base it on the railroad commission permit is when I find out about the job or reach an agreement with the producer, oil and gas company. We immediately turn the Texas Railroad Commission permit in. They usually take about 4 days to return that permit, and we start within usually right there by the same time we get that permit.
And so if you have jobs that really were completed before you ever could get anywhere with the city on trying to get an answer or an agreement made with them about trying to get a permit?
That is correct.
The time that you posted a bond, what happened with that?
I was able to get a permit pending my bond. The day I got the bond is when they signed off on the permit. I believe maybe 7 to 10 days later after we started that job, they filed on the bond
So they were trying to collect the $150,000 bond.
in full.
And is that because they claimed there was damage done to the road?
Yes,
Are these trucks hauling drilling mud to your land farm operation the only commercial vehicles going down Sassine Avenue?
no, ma'am.
Do the pipeline companies bring their own vehicles down Sassine Avenue?
Yes,
Do you know your neighbors on Sassine?
some of them.
How many people live on Sassine?
I believe two.
And I mean, how many residents are there? 2, 3 homes?
I don't think there's 4 total. Some of them, I believe one of them's a man.
Okay, so one of them nobody lives in.
I believe that's correct.
And are you familiar with your neighbors and the businesses they run?
2 of them.
Okay, what do they do?
Mr. Artola runs a trucking company, out of his residence, and has a small lay-down parking lot beside his house.
Does he bring commercial vehicles or down Sassy Avenue?
Multiple, pretty much every day.
Does he park them at his house?
Yes, he does.
And that's actually residential property, correct?
I believe he's on residential.
Do you know of being able to park commercial vehicles as being one of the land uses, for residential
You know, ma'am. It's not-
property? And then, your other neighbor, what does he do?
the
Or the
neighbor-
other end of, the other individual, I think?
Yeah, the neighbor right south of Artola, I don't know the name of the construction company, but they run a construction civil, I believe they do a lot of civil work, but it's a construction company.
Does he also bring commercial vehicles on Sassy Avenue?
Occasionally,
Now, to your knowledge, are these the people that are calling the police when they see a commercial vehicle going into your property?
to the best of my knowledge, yes.
And to your knowledge, have they ever been required to obtain any kind of permit from the city to use Sassy?
No, ma'am, not to my knowledge.
When you first started doing the land farming, what was the permit process?
Well, in the beginning, they didn't really have a process. They didn't have an application, I know that.
Okay, is that something that's just been evolving?
It's definitely grown.
Gonna hand you with the Marcus Defense Exhibit 19 through 26. Are these photos that you yourself took of commercial vehicles on South Avenue?
Yes, it is.
Do they fairly and accurately depict what's shown in photos?
Yes.
I was offering to evidence Defense Exhibit 19 through 26.
Yes, everything.
Objection as relevance, Your Honor. This isn't even or Mr. Thomas's property. This is property of other residents on Sassy Avenue.
Your Honor, the relevance is that their position is that this 106-8 requires a permit to drive a commercial vehicle down a no truck route, Sassy Avenue. And these are photographs of other commercial vehicles on Sassy Avenue. I would say it's very relevant.
Is this all the photos in the 8,900 blocks of Sassy?
Yes, Your Honor.
Okay, objection overruled.
And do all of these photos show big commercial vehicles parked on Sassy Avenue at your neighbor's homes? Or on the street?
Yes, either at the house or on the street. Yes.
If you would look at Defense Exhibit 1, which is ordinance 106-8. This ordinance is entitled The Use of Certain Designated Roadways by Construction Companies. Do you run a construction company?
No, ma'am.
It says no person shall operate construction equipment or vehicles in excess of legal load limits, yada, yada, yada. Do you operate construction equipment?
No, ma'am.
It says contractors desiring to operate construction equipment. Do you consider yourself a contractor desiring to operate construction equipment?
No, ma'am.
And it says you must first make an application with the Director of Public Works. Ms. Flozell Roberts that came and testified, specifying the particular area of construction and the time necessary to complete the work. Do you feel like that applies to you?
No, ma'am, it does not.
Is it your position that that does not even apply to what you're doing? Thus the permit is not required anyway.
No, ma'am, I'm not a contractor. It's not, I don't feel it is required.
Even knowing that, and even knowing that 106-41 provides an exception in certain circumstances, which I know you believe are present at your home, did you still attempt to try to comply and get a permit
Yes, I did.
to appease everybody?
Yes, ma'am.
106-8. I mean, do you think that you're the proper party to obtain a permit? If one was required?
I'm not, if you're referring to the mud truck, I'm not the operator.
Do you think that Mr. Mathis should be required to obtain a permit to drive the trucks in?
Absolutely.
You think he should be the person punished for the fact that one does not exist?
No, ma'am.
On the day that, the ticket was written, were you out at the property?
Yes, ma'am.
And, did the chief of police come out?
I believe that was the same day. Yes, ma'am.
And were you able to speak to him?
Yes, I did.
And what was that conversation about? Do you remember?
It was really short. I think he was getting complaints. He just really came out and looked.
Objection as to hearsay, Your Honor.
He's already testified, Your Honor,
Objection sustained.
but, did you have any reason to believe the truck should not continue coming in and dropping the drilling bed?
No, ma'am, not after our conversation.
Was there confusion about, I mean, had the police come out before and not written tickets?
Bill multiple times.
Do you think there was confusion amongst the police or the police department about whether or not they should be trying to enforce that 106-8, whether or not there was a permit requirement?
I don't even know if they were aware of it, but they were definitely.
But before the tickets were written, you didn't have any reason to believe they were about to start ticketing the drivers.
I had no indication, no, ma'am.
And if truck drivers hauling drilling mud into your land farm operation are getting ticketed, they're not gonna wanna come back, are they?
That's correct.
Because their CDLs are then in jeopardy.
Yes, ma'am.
And does that shut down your business?
Yes.
The other entrance, the one that goes over the LMBA canal, do you have to essentially pay for that entrance?
To 3 different entities, yes.
And, does the LMBA actually require you to, have a bunch of, insure it, pay for a bunch of insurance?
Yes, they did.
How much?
I believe it was a $3 million policy.
But that's not a public road, it's just a very small private entrance that you have to pay for.
Yes, ma'am.
Okay, witness.
Ms. Simmons?
Just as precaution before we get started, while outside, did you happen to speak with any of the jurors?
No.
Did you have an active permit to use Sassy Avenue on the 30th of 2023?
That's the day we finished drinking. No, I did not.
Do you know if Mr. Mathis had an active permit to use Sassy Avenue on that day?
That might be, I'm sure he didn't.
As a matter of fact, you said you weren't aware of the trucks that were coming and going, correct?
I'm aware of the trucks.
You're not aware of each truck individually.
No, ma'am.
Okay, so would you agree it's not your responsibility to ensure who it is that actually had permits for Sassy Avenue?
Say that again, please.
Would you agree it's not your responsibility to ensure these other truck drivers had permits?
No, ma'am.
No further questions, Your Honor. I'll pass it away.
Mr. Scott?
Hold on just a second.
Okay.
Mr. Thomas, are you simply trying to use Athena Avenue for commercial vehicles because it's the safest and only entrance into your property for commercial vehicle use?
Yes, ma'am.
And are you trying to use it the same as your neighbors?
Seeing no further questions, please witness.
Okay, that is witness be excused.
Yes, Your Honor.
Okay, Mr. Thomas. You may be excused. You have a blessed day. Ms. Scott, do you have any other witnesses?
No, Your Honor, defense rest.
Okay, State, do you have any rebuttal? Do you have any rebuttal witnesses?
No, Your Honor.
Okay. Okay, ladies and gentlemen, both the state and the defense have rested. And so the court has to prepare a charge. And once the court prepared a charge, we will have a charge conference, the court and the two lawyers. And that's going to take us a little time. So at this time, we'll be on a break. Now you can, you're going to follow the bailiff into the hallway. This may take a while. So just kind of stay close or nearby. It may take 30 or more minutes. Okay. So at this time, everyone, please stand as the jury exit the courtroom. The court will be in recess. Okay, everyone may be seated. Let the record reflect that the court is back in session and call number 23-CCCR 2380, case the style of the state of Texas versus Roderick Dwayne Mathis. Let the record reflect that Mr. Mathis is present in court with his attorney, Attorney Leslie Scott, state is president, assistant district attorney, sitting first chair Haley Simmons, and sitting second chair, Mr. Andrew Hubel. Let the record also reflect that the jury is now present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the court's charge. Members of the jury, the defendant, Roger Dwayne Mathis, stands charged by complaint with the offense of knowingly, intentionally, and intelligently operate in the 8900 block of Sassine Avenue, a vehicle exceeding 10,000 pounds gross weight on a street other than a designated truck route, disregarding a posted no truck sign without an agreement with the city of Port Arthur in violation of section 106-8 Port Arthur Code of Ordinances, alleged to have been committed in Jefferson County, Texas, on or about the 30th day of March 2023. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits an offense if he violates any provision of this section 106-8 Port Arthur Code of Ordinances, or fails or neglects to comply with the terms of section 106-8 Port Arthur Code of Ordinances, use of certain designated roadways by construction companies, which states as follows: notwithstanding the provisions of section 106-7A, no person shall operate construction equipment and vehicles in excess of legal load limits on streets other than those designated for commercial vehicles, except in accordance with the following provisions. In connection with the following agreement, the applicant shall furnish at his expense a corporate surety performance bond as set forth in the prescribed agreement in an amount determined by the Department of Public Works based on the estimate cost to the city at the time of the agreement for materials, labor, and equipment which would be reasonably necessary to reconstruct the particular roadway discovered or covered by agreement. The city's prevailing contract costs of like materials, the city's prevailing salary costs, and the city's prevailing schedule of operating costs and or the prevailing rental costs of equipment. Contractors desiring to operate construction equipment and heavy trucks exceeding 10,000 pounds gross weight, but not to exceed 48,000 pounds gross weight or 18,000 pounds axle weight on streets other than designated truck routes shall first make application with the Director of Public Works specifying the particular area of construction and the time necessary to complete the work. Upon receipt, the Director of Public Works shall ascertain and designate the particular roadways capable of sustaining the excess load and the duration, and thereafter causes to be executed an agreement between the contractor and the city. Our law further states as follows. Section 106-7, Port Arthur Code of Ordinances, use of streets by commercial vehicles. 8, the chief of police and his designee and the director or public works are authorized to determine and designate those streets upon which commercial vehicles exceeding 10,000 pounds may be prohibited from operation. So that you may better understand the nature of the offense which the defendant is charged, I now define certain terms and words. A person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. A person acts with criminal negligence or is criminally negligent with respect to circumstances surrounding his conduct or the result of his conduct when he ought to be aware of a substantial or unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Now, if you find from the evidence beyond a reasonable doubt, notwithstanding the chief of police or his designee and the director of public works being authorized to determine and designate those streets upon which commercial vehicles exceeding 10,000 pounds may be prohibited from operating, that on or about March 30th of 2023, in the territory limits of the city of Port Arthur, Jefferson County, Texas, the defendant, Roderick Dwayne Mathis, did then and there knowingly, intentionally, or reckless or negligently operate construction equipment and vehicles in excess of the legal load limits on streets to wit, the 8900 block of Sassine Avenue, designated no trucks, other than those designated for commercial vehicles, except in accordance with the following provisions. In connection with the following agreement, defendant failed to or neglected to furnish at his expense a corporate surety performance bond as set forth in the prescribed agreement in an amount determined by the Department of Public Works. Based on the estimated cost to the city of the time of the agreement for materials, labor, and equipment which would be reasonably necessary to reconstruct the particular roadway covered by the agreement. And if you find from the evidence the defendant to be a contractor desiring to operate construction equipment and heavy trucks exceeding 10,000 pounds gross weight, but not to exceed 48,000 pounds gross weight or 18,000 pounds axle weight on streets other than designated truck routes, failed or neglected to first make application with the director of public works specifying the particular area of construction and the time necessary to complete the work, and upon receipt, the director of public works shall ascertain and designate particular roadways capable of sustaining the access road or the excess load, and the duration and thereof, and thereafter cause to be executed an agreement between the contractor and the city, you will find the defendant guilty unless you so find beyond the reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond the reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond the reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and the law, and draw natural and reasonable inferences from such facts. You alone have authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted in the evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make sure or to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page is the verdict page. You can sign in one of the two spots. At the top, it says, "We, the jury, find the defendant not guilty as charged in the complaint of operating in the 8900 block of Sassine Avenue, a vehicle exceeding 10,000 pounds gross weight on a street other than a designated route, disregarding a posted no truck sign without an agreement with the city of Port Arthur in violation of section 106-8 Port Arthur Code of Ordinance." And if that is your verdict, your foreperson will sign here. Or we, the jury, find the defendant guilty as charged in the complaint of operating in the 8900 block of Sassine Avenue, a vehicle exceeding 10,000 pounds gross weight on a street other than a designated truck route, disregarding a posted no truck sign without an agreement with the city of Port Arthur in violation of section 106-8 Port Arthur Code of Ordinance. If that's your verdict, you will sign here. Does everyone understand? Okay. Okay, ladies and gentlemen, at this time, we will have our closing arguments. Each side, you state that each side would like 10 minutes. Is that correct?
Yes, Your
That's
Honor.
correct.
Okay. If you need any additional time, just let me know ahead of time. Okay, at this time, Ms. Simmons, you may open and close.
They would like to reserve, waive the right to open and reserve the right to close, Your Honor.
Okay. Ms. Scott,
Yes, Your Honor.
okay, and I'll be keeping time.
Okay, so I'm the first and she gets to go last, and so what that means is I can't get up and respond to all the arguments she makes. So a couple of things, your verdicts, you'll go back and you'll select a foreperson. And then your verdict has to be unanimous. Okay, so to find him guilty, we'll have to agree. And just remember, like we talked about in Ward R, the state has the burden of proof. Okay, it's on them to prove the elements of the offense, we'll talk about in a second, to you beyond a reasonable doubt. Okay, and remember, we talked about all the different burdens of proof. We talked about in Ward R, down in family court, down the hall. It's a burden called clear and convincing evidence. That's literally the burden that has to be met to take a child away from their parent, from their mother, to terminate parental rights. This is higher than that. Beyond a reasonable doubt is the highest burden in any court, okay, in our justice system. So it is whatever it means to you. You'll know, you've listened to the evidence. It has been proven to you beyond a reasonable doubt. You can request the exhibits, and I would submit to you that you should. The two of them, so the defense exhibits are law. This law is, this ordinance you've heard referenced over and over, 106-8, is also contained in the charge the judge just read to you, okay? This other, well, let me talk about this one first. So the law is given to you by the judge, it's contained in this charge. This is what the state has to prove beyond a reasonable doubt for you to find Mr. Mathis guilty. It's multiple things really. And you'll be able to read it, and if it's confusing, I would submit to you that it is very confusing. It's confusing because these ordinances were written in 1961. And quite frankly, it just doesn't apply to this situation that Mr. Mathis is in. But you've got to read through this and determine if this applies here. He was driving a vehicle over 10,000 pounds. I would submit to you that you can read this, and it talks about a vehicle not to exceed 48,000 pounds or a gross axle weight of 18,000 pounds. There is evidence that it was over a 10,000 pound vehicle. These trucks are usually like 80,000 pounds. Mr. Thomas testified. These trucks that are hauling drilling mud are usually like 80,000 pound trucks. But this does not apply to Mr. Mathis. I would submit to you, he is not the person if a permit was required, which I do not, it is not. It's not because it's not a construction company, but if it was, The driver of the truck would never be the person that the city would expect to go post $150,000 bond. This is what Mr. Thomas testified. He posted when he did obtain the permit. It would never make the truck driver do that and submit an application into the city with information he doesn't have because he's just hired to drive the truck. And I pressed Flozell Roberts, who's the director of public works, about that, and I wasn't trying to be ugly to her. It's just that she is the designated person to make these decisions. And she couldn't even tell you. Nobody could definitively tell you who, if a permit is required, who's required to get it. The pipeline company that's sending the mud, the trucking company that's sending the trucks, Mr. Thomas. Mr. Thomas has had a permit and has attempted to obtain a permit, even though he doesn't, I would submit to you, there's no evidence that he, as a landowner, is required to have one either. Don't be confused because he does have to have a permit from the Railroad Commission to do the land farming. Okay, that's separate. To be able to dispose of the drilling mud on his property, he does have to have, that's a whole different deal. But they can't even tell you who it is. And she really did not want to answer that question. And she finally said any of them. But they just need to decide, they need to figure it out. But you look at this ordinance and you can request these documents. This language is tracked in the charge anyway. And the title of it, use of certain designated roadways by construction companies. I mean, this just wasn't a construction company, not a construction job. That is referenced multiple times throughout this statute. Like, I don't want to bore you with it, because I know I've said it over and over. But Mr. Thomas testified, you know, this, let's see, this is not construction equipment as it talks about. I mean, all of these things need to be shown here. It says in your charge, if you find beyond a reasonable doubt that the vehicle exceeded 10,000 pounds, that he did intentionally, knowingly, and negligently operate construction equipment. I mean, that's what it says in here. That's what you're deciding. He wasn't operating construction equipment. And it goes on, and that the defendant failed to or neglected to furnish a corporate surety performance bond. No, he didn't do that, but that is not required of him. And then it goes on, and then the bond, it tells you it's for materials, labor, equipment. And if you find from the evidence beyond a reasonable doubt that the defendant to be a contractor, he's not a contractor, he's a truck driver, desiring to operate construction equipment. I mean, this just literally doesn't even apply to this situation. And it goes on, like, you've got to find all these things were proven beyond a reasonable doubt. He failed or neglected to first make an application with the Director of Public Works, specifying the particular area of construction and the time necessary to complete the work. I mean, he didn't do that because this wasn't a construction job, and I don't really know what else to say other than this section 106.8 does not apply here. And because it does not apply, a permit was not required of anyone, but most certainly not of Mr. Mathis. And so he should certainly not be the one punished. If Mr. Thomas was required to obtain a permit, maybe he could be ticketed or fined. But I submit to you, he is not, because he is not operating a construction company, construction job, or construction business. But even if you believe that it applies, and I would ask you to take note that even the officers, none of those stage witnesses were really very familiar with these ordinances. Even the police officers that are writing tickets under them, they don't even know about this. They're just writing a ticket because someone told them to go write a ticket. But then you hear, well, there's another ordinance. It's not contained in the charge, but it is an evidence, which means you can request it. It's Defense Exhibit 2. You can look at it, you can read it. It's lengthy. You don't need to read the whole thing. The section that applies is B number 13 down here at the bottom. And that is the one I read over and over and asked about because it provides an exception. It literally says the Department of Public Works, combined with the police department in conjunction with the chief of police, can designate the routes of streets which can be followed by commercial vehicles. and on, and then it says, no such vehicles shall be prohibited from using any street for purposes of going directly to or from any residential, commercial, or industrial establishment abutting on such street for purposes of routine commerce, provided they enter the street at the closest intersection to the destination and proceed no farther than the next intersection in order to return. And honestly, that is exactly what was happening here. They couldn't use the other entrance. It was like not a viable option at all. And Mr. Thomas is not, his vehicles were not the only one using Sassine Avenue. Then you find out, why are the police even going out there? This is not like a heavily populated, this is not a neighborhood with a ton of people, houses, kids and all that. There's like 3 houses, 1 vacant. And there's 2 neighbors that live there. And then you hear, well, one owns a dump truck company, and one owns a construction business, and they run commercial vehicles up and down Sassine Avenue for their own businesses and park them at their residential neighborhoods. And you can request these photos, Defense Exhibit 3 through 17 are pictures of Mr. Thomas's. Well, 2 of them are just Sassine Avenue, and we'll show you the street we're talking about here. And this is his entrance here into his place, and these are like the little houses. It's just like a Google Maps of it's a little street. Here's a picture of it. I mean, this is the street we're talking about. But, and this is like just the entrance into Mr. Thomas's property. But you'll see these pictures that show his business, basically. It shows on his property, some of his trucks, his shop, all that kind of stuff, just to kind of show you that that's where he's working and running his businesses. But then we've got Defense Exhibits 19 through 26 are all these commercial vehicles. Y'all can, I could have helped you around, but y'all could just request one and look at them. All these commercial vehicles, like big trucks, parked out there on Sassine, from all his neighbors, or his two neighbors, doing what they want to do with no ticketing, just keeping the vehicles out there. I don't know what the deal is with him and his neighbors, that they are calling the police on him using Sassine Avenue for commercial vehicles when they do it, but they are. Nobody's trying to make them get a permit, nothing. You heard Mr. Thomas talk about that process. It was really non-existent when he started this type of work. It's just kind of evolved into this thing. But I would submit to you that if you believe this section applies, 106.8, which it just doesn't, that there is an exception to that. And even though it's not written in this charge, you can look at this, it's in evidence, and you can read it for yourself and say, well, yeah, there was testimony about all of these things. I made sure of it. There was testimony that these are commercial vehicles engaged in the steady hauling of material, carrying usually longer heavy loads, that they're operating in routine commerce. This is very routine in the state of Texas and Southeast Texas, the hauling of drilling mud, with the number of pipelines being drilled in our area, it's done daily. And that they were entering and returning the easiest, safest, quickest way possible. This road literally dead ends into his property. It's the only way in, and the only way for him to run his businesses. So Mr. Mathis is not guilty. He should not have been fined for this. And you heard him testify. He's been stopped on the truck routes before, but he said, well, anytime I show an officer that, no, this is the only way, they don't ticket you because they know that you can, if it's your only way in, as long as you're not cutting through or something like that, you can do it. And I would submit to you that he should not be punished for this and that he should not take a hit on his CDL for this. But I think the best thing you can do is read the charge, section 3, really outlines all of those elements, all of those things that you are having to say the state has shown you beyond a reasonable doubt to find him guilty, and those things are just not present here. They just are not. And so I would ask you to find him not guilty. Thank you.
Okay,
Thank you.
Ms. Simmons, Ms. Scott, took 12 minutes and 22 seconds. So you have 12 minutes, 22 seconds.
Thank you, Your Honor. All right, good afternoon. First and foremost, I want to thank everybody for their patience. I know this has been drawn out. There's a lot of back and forth, but I thank you, the state thanks you, the defense thanks you for taking your time, giving us your attention to come in here and pay attention to the evidence and the facts and the testimony of this case. So I want to first off start by reminding you of the elements of this case. These are the elements that we have to prove beyond a reasonable doubt. And I want to say that the defendant himself actually established these elements during cross-examination. And that is that in the city of Port Arthur in Jefferson County, Texas, the defendant, Mr. Mathis, on or about March 30th, 2023, did then and there knowingly, intentionally, or negligently operate a motor vehicle exceeding 10,000 pounds on a street other than a designated truck route without a permit. Mr. Mathis actually testified to the fact that he didn't even need a permit, yet we saw on body cam, as soon as he was stopped, he said, "I thought I had one." I want you to pay attention to that. You can request the body cam, it too is an evidence, you can take a look at that. That is your choice, I ask that you do. You've heard the defense argue an exception, and I want to point out that this is not an exception, it's simply a separate ordinance. And that's 106-41B13. Keep in mind that both Chief Duraso and the Public Works Director, Ms. Flagell Roberts, and let's focus on Chief Duraso first. He came in and he had said that he had ran into the defendant prior to him ever receiving this citation. And he had, by grace of God, he gave him an opportunity to leave. He even followed him out. He gave him a warrant. Yet the defendant, Mr. Mathis, proceeded to keep proceeding on the route, on this no designated truck route. He even admits that he saw the sign every single time. This isn't a matter of the defendant not being familiar with where he's at. This is simply a matter of the defendant just blatantly disregarding a no truck route. And keep in mind, Chief Duraso also testified to an alternative route that was available to him. And the defense had a witness, Reagan Drawdy, come in and say that the other route was difficult. But Mr. Drawdy actually testified himself that regardless of difficulty on other streets, the ordinance should still apply, which is why we're here today. And let's move to the Public Works Director, Ms. Flagell Roberts. Ms. Roberts is over the application process. She testified that she actually handles it. She works in conjunction with the Department of Public Works in going through the entirety of the applications. And this is not an issue of improper party. She testified to the fact that Mr. Mathis had the ability to submit an application with the Department of Public Works. As a matter of fact, she also testified that his employer could have done so as well. So I ask you pay close attention to these facts, and the fact is that both the chief of police in conjunction with the Department of Public Works play a deciding role in the specific ordinance at issue, both of which testified before you today and stated that, or this week, that Mr. Mathis did in fact need a permit. And the reason we have these road use agreements and permits, and these words have been used interchangeably throughout this trial, it's to ensure that there's no damage to the roads. And these are roads that are residential in nature, roads that are actually designated as residential within the city limits of Port Arthur. So imagine living on a street where you have heavy traffic and heavy loads, heavy equipment loads being come in and out of your property, and your roads are deteriorating as a result. And that's one of the reasons we actually, or the city of Port Arthur actually has the bond requirement. So you can post the bond and make sure should any damage be done, the damage can actually be repaid for in the process. And nowhere in the ordinance does it apply an exception because there's an alternative route is deemed to be dangerous or difficult. And simple, it could all have been avoided just by the application process of the permit. And the defense argues that it's not a heavily populated area, but regardless, we're made aware throughout the defense testimony or the defense case in chief that the residents have been calling to complain, not just on one occasion, not on two, but on several. So the defense called to the stand Mr. Kirk Thomas, and I really want to kind of dig into that testimony there. He's not the boss. He's not the employer of Mr. Mathis. And keep in mind, he has no authority whatsoever to actually grant road use permits. And he had no permit for Sassy Avenue himself, which is separate and aside. He's not the defendant in this case, Mr. Mathis is. So Mr. Thomas essentially has no bearing on this case whatsoever. And he's not even aware of the trucks coming and going through Sassy Avenue. He sees them, but he has no authority to stop them. He can't tell them to go apply for these permits. So why would it be his responsibility and come in and testify on Mr. Mathis' lack of having a permit? And of course, Mr. Thomas states that he had posted $150,000 bond at one point to actually go through the proper process, go through the proper channels of getting a permit from the city of Port Arthur. He went through the process. He infers to you that there is a proper process to be followed, one that Mr. Mavis did not do. And he talks a lot about the neighbors and what the neighbors are doing, but I want y'all to not get swayed by those facts. Because once again, we're here for Mr. Mathis. What the neighbors are doing, it's not negating what the defendant was caught doing here. And drilling mud, I really want to focus on that. The defense has led a lot to say that that's not construction. However, when Mr. Thomas actually took the stand, he had said the process of drilling mud is the byproduct of laying pipe. And his testimony itself is an aspect of construction. Even more so, he testified to the fact that these trucks were coming and go, were contracted in. His employer could have actually applied for the permit. He could have applied for the permit. Lack of funding is not the issue here. And Mr. Thomas, he actually rendered legal opinions on the ordinance. He has no legal expertise. He has no legal background whatsoever. His opinion of the ordinance and as it stands is not proper. His property itself may be zoned for heavy industrial, but it doesn't negate the fact that Sassing Avenue is actually residential. It is zoned for residential use. It's not your job to assess the neighbors. It's not your job to assess what Mr. Kirk Thomas is doing. It's your job here to look at Mr. Mathis and see where his doing wrong. So the state has met their burden. In fact, Mr. Mathis admitted to every element on the stand when I went through cross with him. And after you've looked at all the facts and the evidence, which you can ask for, you're more than welcome to ask for any of the exhibits that have been admitted in. I ask that you find in favor of the state and return a verdict of guilty. And I thank you for your time.
Right. Okay, ladies and gentlemen of the jury, both sides have completed their closing statements. Going to give the bailiff copy of the charge that you will bring into your jury room with you. Everyone please stand as the jury followed the bailiff into the jury room. Uh-oh. Okay. Order being recessed, jury come back with a verdict. Okay. Y'all ready? Y'all ready? Okay. Let the record reflect that the attorney for the state and attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? Everyone, please say when the jury comes in. You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Four-person. Have you reached a verdict in this case?
Yes, sir.
Is it a verdict that has been reached is one that is unanimous? Is it a
Yes.
unanimous verdict?
Yes.
That is one that is agreed upon by all the members of the jury,
Yes, sir.
okay? Would you please hand the verdict? Okay, the play. You may be seated. Mr. Mathis, would you please stand? And cause number 23 CCCR 2380, State of Texas versus Project Dwayne Mathis. It states that we, the jury, find the defendant not guilty as charged in the complaint of operating in the 8900 blocks of Sassine Avenue, a vehicle exceeding 10,000 pounds, gross weight on a street other than designated truck route, disregarding a posted no truck sign without an agreement with the city of Port Arthur in violation of section 106-8, Port Arthur Code of Ordinances, okay? You may be seated. Does anyone, would anyone like the jury to be polled?
No, you're right.
Okay. Ladies and gentlemen of the jury, I'd like to thank you for taking time out from your busy schedules to be here. I know we had the holiday on yesterday, so that kind of stretched it out a little longer than we usually have our cases. First of all, I'd like to thank you for taking time out from your from your busy schedules to be here today. I know that at one point you were scheduled to come on Tuesday, and then you got word that they had moved it up to today. What happened was you were supposed to be next door in County Court at Law number 3, but he didn't have a trial. We needed a jury, so we got y'all. Okay, and so we happy we got you. And again, I know you on yesterday, well, the day before yesterday, when we actually picked a jury on Tuesday, I told the members of the panel that anytime that they're in the area, please come and have a seat in your courtroom. And the reason why I'm saying this your courtroom, because I'm only a public servant. Now you see my name over the door, says County Court at Law number 2, Judge Terrence L. Holmes. I'm the judge here. This is not my courtroom. This is your courtroom. You're the citizens of Jefferson County. So anytime that you're in the area, please have a seat in that area. We call that the peanut gallery. And as you know, You can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and see what goes on in your fort. Now, the bailiff, I have some letters for you. And he's gonna give each and every one of you a letter. I think our district clerk's office is closed at this time. If you need anything from the district clerk's office, or if you need any excuses, we should be able to type up something for you so that to indicate that you were here today and the other days. And the district clerk's office is aware of the time that y'all came on Monday, and you will be compensated for your service that you have provided here to Jefferson County. Again, on behalf of citizens of Jefferson County, I'd like to thank you for being here today. I also tell people to see, I usually give everybody a handshake, but we still have COVID in our community. However, I can give you an air handshake. So at this time, I'm gonna give everyone an air handshake. Thank everybody for coming out. And we ask that God would continue to bless and keep each and every one of you. You're excused. Oh yeah, make sure you turn in the tags. Yeah, you can put them right up there. And the bailiff have letters for you, so when you leave, he'll hand each and every one you like. If you'd like to have any comments or anything, you could just drop us a line. At this time, again, ladies and gentlemen, also, if the attorneys would like to talk to you, you do not have to talk to them if you don't want to. If you want to, that's fine. You can talk to them, but you don't have to. All right, that's your choice. All right, at this time, ladies and gentlemen, thanks for coming, and y'all have a blessed day.
Thank you.
You're welcome.
Yeah.
Okay.
Go ahead.
Oh. I didn't know-
What?
I didn't know she knew him.
It was everybody.